Kumar and other participants will also highlight. But we should see these today's discussion for an hour and a half as only a beginning, so that we can all start thinking about this judgment much more seriously. Because what I have seen is that people have taken it very lightly. That a judgment has come from the Supreme Court giving back, the control over the temple to the royal family, and the people, there are enough people to think that's really not so important. They're really beyond royal family and beyond all this, and they are interested to go to the temple, which is a very great and ancient temple, and as long as they're able to go there and pray and get spiritual solace, beyond a point, they are not paying attention to the significance of this judgment. And so I think we, through this short discussion, perhaps our main aim is to raise questions about the judgment, which are in our own mind, share those questions so that we can all start thinking very carefully about this very important judgment. So with that introduction, I'll just say one more thing. I feel very uncomfortable in referring to using the words ruler, royal, and so on, because ruler is ideologically neutral. The dictionary says any person exercising dominion or government is a ruler. So it can be any ideology. A royal means having the status of a king, not past status, current status. It is like the mistake of calling a retired judge justice, or a retired professor like me professor. It's not. It indicates a status which, unlike professor and justice, we have removed that status from we had a revolution to remove the status. So I don't like to use. So the most accurate word to say is that Mr. Balarama Varma was the last, not royal, because that is all neutral. He was the last dictator of Travancore. For all of us who are born and brought up in Travancore, I was born in Travancore, Cochin. He was the last dictator. What is the definition of the word dictator? It means a ruler with total power over the country, obtained by force, not through consent. So we have no hesitation saying Marcos was a dictator, X was a dictator, Y was a dictator. But when we say this is the family of the last dictator, not the last ruler of Kerala, we have some difficulty. But sometimes it is important for us to remember that, because then we will understand the significance of this judgment, that this control over this most ancient, sacred, fabulously wealthy temple is being given back to the family of the last dictator of Travancore. And that is not something that the people of Travancore, who have sacrificed a lot to end the dictatorship, should take lightly, because it has, as Professor G.Mohan did not say this, but it has a lot of legal significance. So I'd like to today suggest that there are, I'll just mention very briefly, five legal issues which I see coming out of this judgment. I will also mention 4 constitutional issues, and then finally 2 social issues. And I will only mention them and not discuss them. We can have another session if you wish me to discuss it in more detail. The 5 legal issues I'm raising, some of this has been already covered by Professor Jayakumar, but I'm just listing them. The first legal issue I have with the judgment is that its factual basis is erroneous. It is not based on proven facts. It is taking a quotation from here. It is actually taking a quotation from the specially petition filed by the younger brother of the last dictator to establish the history of this temple. And so the judgment is ahistorical. Now that's very important for a reason that I'll come to establish the history. Now we are not historians, we are lawyers, and therefore we know that there is a legal method for establishing and proving facts. The Evidence Act applies to all adjudication in the country. And some principles of the Evidence Act, not rules, but the principles of the Evidence Act must be applied to establish facts, because on the facts of the case, it all turns on facts, because two sets of facts are agreed. One, as Professor G.Mohan said, it's a public temple. There's no dispute. Second, there is no dispute by the government, but it's a legal concept I have difficulty with. But it is agreed by all the parties that the owner of the wealth of the temple and the Pandaravagam property, from Pandaravaga property, is the deity, the juristic entity, the artificial legal entity called the deity. That is agreed. The question is, how does this lead to a decision on the family getting control over the deity and the properties of the deity? That is based upon, as Professor G.Mohan said, a reading of history. And that reading of history is not based on proven facts. So my first legal point is that the normal legal standards for proving facts have not been met in the Supreme Court. And this is particularly important, I'm jumping a little ahead, because the decision of the Supreme Court rests on one principle alone, and that is that the successors of Mr. Balarama Verma are Shabbaites. Now, the status or role of Shabbaite, the office of Shabbaite, is based on certain facts. Was the person who is a Shabbaite the founder? Question of fact. Or if he was not the founder, did the founder appoint him a Shabbaite? Also a question of fact. If he's neither the founder, nor was he appointed by the founder as a Shabbaite, then is the person who's claiming to be Shabbaite a de facto Shabbaite? Because he was, as a factual matter, protecting the deity, being the representative of the juristic entity called the deity on earth, the ministrant of the deity, as judgments have said, as a matter of fact. But that is also de facto, means as a matter of fact. So either de jure or de facto, you have to be a Shabbaite. And they are claiming that the Padmanabha Swami temple was founded in 1735 or so, when it was reconstructed by Martanda Varma, when the Kerala High Court has already established and said conclusively, as a matter of fact, that it's a much more ancient temple. And its origins are lost in the mists of time in antiquity. We don't know if there was a founder or who the founder. There are lots of stories. Many people who believe that this was actually the temple of the local Dalits. And the role of the Dalits is associated with this temple. We don't know. There are lots of stories. But the fact of the matter is that they have now, the Supreme Court of India has said Padmanabha Swami temple was founded only in 1725. So we cannot any longer claim that this is an ancient temple. This is like saying that the Akal Takht was founded few years ago when it was reconstructed after the attack during the army action against the terrorists who were in the temple. We can't say that because it was reconstructed by somebody, that person is a founder of the Akal Takht. The Akal Takht has a very old ancient history. The buildings may be reconstructed, but the temple is not just a set of buildings. And so the Supreme Court has had to come to the ahistorical and erroneous factual conclusion that Martanda Varma is the founder of this temple, in order to then say that he's a Shabbaite of the third kind, de facto Shabbaite, not the Shabbaite not the third kind, the first kind, the founder, Shabbaite being the founder. So first legal point is that there is the factual basis of the judgment is very weak and erroneous or wrong from a legal point of view. Second is the legal principle on the basis of which control has been handed over to the family is again irrational and legally wrong, unsound. Why? Because there are only two grounds, legal grounds, on the basis of which control has been handed over to the family. One is they are successors of Martanda Varma, and Martanda Varma was a Shabayat. And Shabayatship has a office element, function element, fiduciary element, but also has a inheritable private property element. Now that raises a number of questions because the question is, as Professor G.Mohan also said, that for a dictatorial sovereign, there is no distinction between public and private property owned by the sovereign. That's a well-established legal principle because he has complete power. That's why I say we have to understand him as the last dictator of Kerala, because present generation cannot understand that he was simply a ruler, right? Because today the chief minister is also the ruler of Kerala. Very, very different. So the principle is that a sovereign has the power, he's above the law. So if he says this is my property, it is his property. So it's a third species of property, sovereign property. It's not public property or private property, which are both derived from the law that the sovereign makes. So when the sovereign, gives an endowment, he's giving an endowment which is certainly not private. It may not be public, but it is sovereign. Now, how can you convert a feudal sovereign right, a dictatorial right, a right that flows from a dictatorial role in society into inheritable private property? And we have a very clear judgment which has been discussed, but not properly discussed in the Supreme Court judgment, is the Tilkayat judgment, where the claim was similarly that the successors of Tilkayat are saying that this is a private temple and we are successors of controllers of this temple. The Supreme Court, Justice Gajendra Gatkar, rejects that. Have a place. It's a public temple. And therefore, the government was right to enact a legislation and take control of the property and protect the deity. So the Shabayat, the law, the legal principles governing the definition of Shabayat are not satisfied in the case of Martanda Varma. He could not have been a Shabayat. It is also there is another problem with Martanda Varma being a Shabayat. As I said, very well recognized as a legal principle in Indian jurisprudence for over a century now, is that Shabayatship gives the Shabayat a private property interest in the debutter property. Debutter property is an endowment created when an endowment is made to a deity. It's called debutter property. To get the usufruct of that debutter property. This is a very well-established legal principle. Now, if this is the principle that the Supreme Court has said, it is a very sad repudiation of the claim of Martanda Varma of Tripadi Danam, where he said, I am surrendering all my rights to Padmanabha. He probably did not tell Padmanabha that I am actually a Shabayat. This is debutter property. And actually, I am now establishing for me and my successors, for generations to come in perpetuity, a private right to benefit from the usufruct, from the economic wealth of this temple, which he did not have as a sovereign. So the Supreme Court judgment actually insults Martanda Varma by mocking the Tripadi Danam and saying it was actually it was actually simply a device for him to derive inheritable private property rights over the economic benefits accruing from the temple by saying, I am actually surrendering everything to you, Padmanabha. I actually do believe that Martanda Varma, given that history, all the violence and all the building up, was probably, and his own family has written suggesting that comparing it to Ashoka's turn to non-violence. Let's accept that. I don't know enough to reject it. let's assume that he was being sincere. I think he would not be happy that the Supreme Court has now put him into the position of a manager who's managing a temple with proprietary private property interests in the temple, which can be inherited for the benefit of his family and his successors, completely incompatible with the idea of Tripadi Dhanam. Secondly, lastly, there is a contradiction between, as Professor Jayakumar knows better than me, there is a well-established contradiction or inconsistency, conflict between the British concept of trustee and trust, which is unique to English law, which we have inherited. We have a 19th century Trust Act, which is still very popular and widely used in our country. And a long catene of Supreme Court judgments has clearly said, including in this judgment, quoted in this judgment, that a trustee, a shabayat is not a trustee. A shabayat is not a trustee. Now, you can say trustee in the general sense of a fiduciary, but not a trustee in the eyes of law. If that is the case, having declared him a shabayat, how can the Supreme Court say that in the judgment referred to the successor of Martanda Varma and Balarama Varma as a trustee? So the committee, nominee of the trustee, the role of the trustee, the Travancore-Cochin Act refers to vesting in trust. It's a legal instrument. It's not a simple general colloquial usage. The Travancore-Cochin Act vests Padmanabha Swami Temple's management in trust. So he is a trustee. But if he is a trustee, according to well-established, in the legal sense of the word, not in the general sense of the word, then he cannot be a shabayat. And if he is not a shabayat, then this family cannot inherit. Now, if he is a trustee, the trust deed has to provide hereditary role, that he is a hereditary trustee. There has to be evidence there is no evidence for that. So, Professor Jayakumar is right. The excellent judgment by Mr. C.N. Ramchandran Nair, Justice C.N. Ramchandran Nair, very, very excellent judgment is correct. That there was no successor, that the ruler of Travancore referred to Balarama Varma, he died, and the successor to that role is the government of the government of Kerala to step into that position of trustee of the temple. Government does not become the owner of the temple, does not become the property of the temple, but like in Devaswam, it becomes really a trustee to protect the deity and the devotees and their rights, accountable to the people. So the logic, the legal logic in the judgment is very flawed, because it is neither shabayat, which they say it is. Then they contradict themselves and say the shabayat is also the trustee, and they may say it is trustee in the general sense, but this word trustee is used in the law, in the legal sense. And the family is also claiming to be trustees in the legal sense. We can't use these words in judgments and statutes in a general sense. These are not colloquial documents. Now I go to the third quick point, which is, I agree with Professor Jayakumar that the interpretation of the word ruler in the Travancore-Cochin Act 1950 and in the Covenant of 1949 is illogical. It doesn't meet any principle on the rule of interpretation. How can you see the word ruler has to be read in its plain meaning, and if you're going to expand it to include all the successors of the ruler in perpetuity, you cannot imply that. There has to be some corroboration, some documentation that there was an intention that this was inheritable, that this was to be passed on to successors. Neither in V.P. Menon's book, in none of the associated legal material associated with either the Act or the Covenant, is there any support for the idea that Balarama Varma claimed, or that the government of India agreed, or the legislature agreed, that this would be inheritable. And so that interpretation is again inconsistent with established principles of legislative interpretation. Then two quick points. One is that the entire issue of the criminality alleged in relation to the property or the temple and the Pandara Vaga properties of the temple, culminating in Mr. Vinod Rai's report and several other interventions, which has been brought up in several cases and before several courts, that is completely ignored in the Supreme Court judgment. And that is very material, because the question is, these alleged loss of property, mismanagement, misappropriation occurred during the period in which the property, the temple, was under the control of this family. And therefore, the question of handing over that temple to the same family is like returning an abused person to the hands of the abuser, without first confirming whether or not the allegations of abuse are true. And therefore, I think it was incumbent on the Supreme Court to ascertain the facts, read and take on board judicially Vinod Rai's report, examine it, come to a factual finding on whether there was criminality or not, and who was responsible, before handing this extraordinarily important property and temple into the hands of people who are alleged to have been party to that misappropriation, without clearing them of that. Finally, the question on the legal issues, the question of the district judge, one which Professor Jayakumar also highlighted. I just want to add this, that in the Supreme Court order in 2014, you know this, interim committee, they had said that it will be chaired by the district judge. But it had said that if the district judge is not a Hindu, then the senior most additional district judge, who is a Hindu can be the chairperson. Here, they have not said that. So the practical implication of this is that the district judge of Trivandrum here and forward will always have to be a Hindu. I'm not saying that that was the intention of the Supreme Court. It may have been an oversight. Perhaps the government may want to go back to the Supreme Court and clarify whether this means, because in Kerala, district judge means district judge, not additional district judge. And the district judge must be the chairman of the administrative committee, and the district judge must be a Hindu. And so unless the Supreme Court clarifies that they are continuing the 2014 principle that this, if the district judge is not a Hindu, the senior most additional district judge who is a Hindu can be the chairperson, we would be violating the constitution in a significant way and engaging in communal reservation of the position of district judge of Trivandrum in perpetuity, or being in violation of the, in contempt of court. So these are my 5 legal issues. Very quickly, Safi, can I have another 5-6 minutes?
Yeah, sir, definitely.
Okay. I have 2 or 3 constitutional issues and 1 or 2 social issues. On the constitutional issues, I'll just mention them quickly. There is no time to discuss them. I do believe that this is a major setback for the constitutional, aside from the facts of the case and the decision which we just discussed. The first is that we have I have for some time been advocating a theory of just institutions emerging from Article 38 of the Constitution, which says that the state shall promote the welfare of the people by securing, as best as it can, a social order in which all institutions of national life shall be informed by justice, social, economic, and political. And so I'm arguing that this is a mandate to create just institutions in India, in our society. And that applies to religious institutions, to family institutions, to public institutions, to private institutions, to corporations. There is nothing that is exempt from the directive principle of Article 38 that our institutions must be just. And this judgment violates that principle because it actually defends and promotes casteism. How does it do that? In two ways. To get into it, but many casteist practices, including that the tantri can only be from a certain social background and so on, are maintained in that in that judgment. But more importantly, it is part of a larger project, which is ironically referred to in this Supreme Court judgment in a quotation from a 1922 Privy Council judgment, Vidya Varuti Tirtha Swamigal versus Balusamy Iyer, 1922 PCAIR 1922 Privy Council, page 123. In that judgment, the Privy Council says, talking about institutions like Shabayat and endowments and debater properties, in other words, talking about the institutions that have been set up to enable Hindu temples to be, and mathams and so on, to be funded. The Privy Council says the following: religious institutions known under different names, I'm quoting, are regarded as possessing juristic capacity and gifts made to them eo nomini. In many cases in southern India, this is the important part, in many cases in southern India, where the diffusion of Aryan Brahmanism was essential for bringing Dravidian people under the religious rule of the Hindu system, colleges and monasteries under the names of Matham were founded under spiritual teachers of recognized sanctity. These men had and have ample discretion in the application of the funds of the institution, but always subject to certain obligations and duties equally governed by custom and usage. When the gift is directly to an idol or a temple, affected by human agency, called by whatever name, he is only the manager and custodian of the idol or the institution. Now, this makes me, this explains in very direct language a project, a social and political project behind the concept of Hindu endowments, charitable endowments, Shabayat, trustee, all that doctrine. And that project is the diffusion of Aryan Brahmanism to bring Dravidian peoples, the local peoples, under the religious rule of the Hindu system. Now, is it not time for us under this constitution to challenge the system and rethink all the law that we have inherited from colonial times and pre-colonial times to keep up a system that is paying for our subjugation? Protecting the, now you understand why the temple had to be handed over people who will carry forward that subjugation, and why the Supreme Court rejected the Guruvayur Devaswam model, where scheduled castes and scheduled tribes, Dravidian people, would be actually on that administrative committee. So this is why it is a major setback to the constitutional project of building a new social order based on equality and freedom. It is also a setback to the project of religious reform, essential at the core of the project of social reform. So I'll just leave it at this because it's a long and a big point. Second, as Professor Jayakumar correctly said, the judgment violates the spirit and purpose of the 26th Amendment of abolition of privy purses, because we wanted to end the inherited rights of former dictators, and that has been set back. The former dictator's family has been given control of vast wealth and vast property. The distinction between sovereign property and private property has been blurred, and it opens up the possibility of former dictators, former Maharajas all across the country to now claim that they're Shabaits of very rich temples, which they controlled in their feudal sovereign capacity and not in a religious capacity. So what the court has done is converted a political right, a political claim, a political decision made by a democratic country into a religious right and protected it in perpetuity. And if this trend catches on, we will find that many rights are now going to be converted into religious rights. This is an extreme argument, but just to show the potential of it, they could claim that Martanda Varma endowed the entire state of Travancore to Padmanabha Dasa as a Shabait. And so now the rulership has been inherited by the family because this is a religious right and you cannot wipe it out. We are all actually, we are all subjects of Padmanabha Dasa with the family as as the trustee of Padmanabha Dasa. So we cannot allow political rights to be converted into religious rights. That violates at the core the principle of secularism, and we must resist and question this. And so let me now move on to the last point, which is the social significance and going forward of this judgment. And I think in addition to upholding casteism and continuing the project of spreading Aryan Brahmanism to bring Dravidian people, I'm quoting the Privy Council, bring Dravidian people under the Hindu system. In addition to that, I think we are opening the pathway for vast amount of wealth to be transferred back into the hands of former Dvija rulers and feudals. And this is a major setback for our project of social change and social reform. I want to conclude by suggesting not in the long term. Right now, the atmosphere is not right, but in the long term, the only solution to respond to this problem is for the legislature of Kerala to bring forward a law on Padmanabha Swami Temple and to ensure that the control of the temple, management and control of the secular aspects of the temple, not the religious aspects, is vested in the state. Because what the Supreme Court is saying, which I don't agree with, is that the interests of the deity Padmanabha are safer in the hands of this family than with the people of Kerala. And I cannot accept that. I think the deity and the deity's property would be much safer in the hands of the people of Kerala, devotees and not